Let's go. Good morning, everybody. My name is Christopher Iannella. I will chair the hearing. Let me introduce to my left, Councilor Terrence Kennedy. To my right, Councilor Tamisha Civil. Next to her, Councilor Mara Dolan. And good morning to you, sir.
Good morning, Councilor Iannella.
Let me read a letter dated June 18th, addressed to the Executive Council. Dear Councilors, I'm pleased to nominate Andrew Don Jr. to the position of Associate Justice of the Juvenile Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. Sincerely, Maura Healey, Governor. Before we hear from you, we'll hear from your witness list. You want to introduce the two witnesses or one at a time?
Yes, sure. My first witness is the Honorable Judge Linda Sable. Is my first.
Judge,
She's the first.
how are you? You can sit, you can stand, whatever you want.
Sit down. So good morning, and thank you so much for having me here. I am really excited to be here and be able to share my thoughts on this nominee, Attorney Andrew Don. Just as way of background, I am a judge in the juvenile courts. I'm the first justice in the Barnstable juvenile courts, Barnstable Town of Plymouth juvenile courts. And I've known Drew for about 20 years. We met when we were both accepting cases in the Brockton courts and representing parents and children, parent protections and guardianships and adoptions, delinquency cases and CRAs and special education hearings. So I have a couple of points I just want to make about Drew. The first thing that I noted, he goes by Drew. The first thing I noted about Drew when we started to practice together was his knowledge of the law. So kind of rose above every other practitioner on the South Shore that I had encountered in the juvenile courts. He knows the body of law in the division that he is seeking to be a judge. He knows the statutes, he's read the statutes, keeps up with the case law, and he utilizes that case law to advocate on behalf of his clients in a way that really sets him apart from the rest of the bar. From the jump, Drew was a leader in the juvenile law. So people just sort of naturally started to gravitate toward him because he knew his stuff. He was knowledgeable on what was going on. When a new case came out, Drew was the first one to utilize it in litigation, to file a motion that used whatever new angle came out that the SJC blessed us with, was able to take in the information and apply it to the facts of whatever case he had and file novel motions. And then other lawyers would follow suit. They'd see what Drew was doing and say, hey, that's a good idea. Can we do that? Do you have that? And very quickly thereafter, CPCS noticed, and Drew became the resource attorney in Plymouth County for attorneys that were handling civil matters in the juvenile courts. And what that means is that the stuff that he had been doing informally, informing everyone of these updates on the case law and giving out motions, he was now in charge and giving trainings and making advice and handling sticky personnel situations. And he made himself available to the bar nights, weekends, days. It was a barely compensated position, so I think you could bill for your time. I doubt he ever did, and he was constantly in with other attorneys looking to him for knowledge. He was a leader. So that's the first thing I want to point out. The second thing was he has excellent trial skills, and he was creative. So he called expert witnesses when other lawyers didn't. He found novel defenses when other lawyers didn't, and that stood out. We had cases together, we were on the same side, we were on opposing sides, and I was never less than impressed with his trial skills. He was prepared, he was on time. He went out of his way to make sure that his clients were there and prepared and ready to litigate. That is not always the case in juvenile court. The next thing I'm gonna move to is his temperament. And I know at these hearings, I've watched a few hearings on YouTube just to familiarize myself, because it's been a while since I was before this body. Temperament, everyone talks about that judicial temperament. Well, I think of judicial temperament as someone who can remain calm, cool, and collected during times of great stress. And make no mistake about it, the cases in the juvenile court are stressful. They're full of trauma, you know, not every day, but pretty much every other day. There's lots of trauma there. He's cool under pressure. He's empathetic. He's compassionate. His clients like him, and the staff at the court likes him. Probation likes him. The clerks are elated when Drew walks in because they know he's prepared. He's not going to come in late. He's not going to make excuses, and he's not going to beg for continuances. As a judge for the last 9 years, Drew has appeared in front of me, and I will say that's kind of a mixed bag. I'm happy that he's there because he is prepared and on time and all that good stuff, but I also know that he's gonna make me work. He's not there to settle cases and, you know, get his clients to just sign off on stipulations or, you know, quickly do a plea. He is going to litigate his cases, so he's gonna put the judge through their cases. So, always, I'm sort of joking about the mixed bag, but I do know there's gonna be work in front of me, and every judge that Drew appears in front of knows that. He is going to make us work because he actually knows the law. He has met with his client, he's prepared, and he's going to file things that I'm going to have to make difficult decisions on. So there's that. He treats people with dignity and respect. The litigants that are in the juvenile court, this is their worst nightmare, their worst day. Either their children have been removed, or their children are facing horrific criminal charges, or even not so serious criminal charges, but their kids in court. It's their worst day. He is able to treat these people with dignity and respect. And that comes from within. That comes from a candidate who actually walked the walk, not just talk the talk. This guy worked at some of the residential homes where I am sending kids for behavioral treatment. He worked there. He knows this population. He worked at the Pine Street Inn with people who are homeless, impoverished, mental health problems. That's who our population is. That's who we're dealing with every single day in the juvenile court. He is intimately familiar and able to treat everyone with dignity and respect. That's so important. I've never seen him lose his cool. Important. He came to visit me in the Plymouth session where I worked a couple of weeks ago. And I was in the clerk's office and he walked in, and all the clerical staff in the clerk's office, now I've only been in that court for a couple of months, right? So I'm not intimately familiar with everyone. He walked in, they all jumped up, Attorney, no, it's here. They were just thrilled that he was nominated for this position. So I looked at him and I'm like, did you practice? I knew you in Brockton, I knew you in Norfolk County, did you practice? A little bit. They remember his own. He's kind to the staff. He goes out of his way to recognize people, to say hello to everyone by name. That goes so far. The other piece of this job that's not talked about a lot is the administrative piece. So not only do you have to sit on the bench, not only do you have to treat litigants with respect, not only do you have to know the law inside and out and make difficult decisions every day, but you also have administrative duties with staff, with lawyers, with clerks, probation officers, court officers, and it's an important part of the job because if you think about it, these people that they go every single day, 5 days a week. There's no remote. You're there. You're serving the public. And as the judge, and this was a part of the job that I wasn't quite aware of when I took it. You walk in that courtroom, everyone's looking to you. You're the leader of that court. They're looking up at you, and they want to know how to behave, what the temperament is going to be. Are you an angry judge? Or do you want to keep everyone at arm's length? And so to see the staff respond to Attorney Don in the way that they did was really heartwarming. I mean, I knew that anyway about him, but it's an important part of the job. And he's gonna be great at that part of the job. He's going to be great at recognizing people who don't make a ton of money and have to come in every single day and have to do the grudge work, have to, dump at things and deal with angry people at the counter. You know that you're appreciated. He's good at that. I already know that. He'll be great at that job. His current position with CPCS, so he's now in charge of really 800 lawyers who private bar, who accept cases across the Commonwealth. Very interesting. I remember when he took that job, I think he was not thrilled. He was really on the fence because he's a guy who likes to get in the trenches. He wants to do trial work. He wants to know his clients. And I think he felt like he was doing a disservice to the population that he serves. And instead, he made the most of that job. He traveled this Commonwealth. I remember texting him one day about something and he got back to me, he said, I can't really talk right now, I'm out in the Berkshires. He was in the Berkshires, he was in Lowell, he was down in New Bedford, crisscrossing the state, meeting with judges, meeting with probation, going to programs for our kids, all over the Commonwealth, just to make sure that the lawyers that are being trained by CPCS have the information they need to do the best job for their clients they can. He took that job and he made the most of it. And again, that's going to serve him as a judge. It's going to serve him. He has connections. He's not shy about getting out to the community, bringing the community to the court and the court to the community, because that's what the juvenile court is all about. So when the governor nominated him, I was thrilled. I'm so happy to have all of that. One is like an encyclopedia. I can pick up the phone and call him and say, hey, the Rashida case came out and I just got this motion. What do you think? Because by the way, we end up doing that a little bit anyway with a private lawyer, quickly sending him a note from the bench saying, I can't remember the name of that case. And it concerns, a point of evidence, getting an affidavit from a social worker. And what's the name of the case? 2 minutes later, the case name came from him. So I am looking forward to having this accomplish. I also see him as a future leader of the juvenile court. There are committees, there are all kinds of issues that come up with the state house and legislatures, and you can be involved or not involved. This guy will be involved, and we need him because we need somebody who's smart and who's aggressive and who has the temperament to form compromises. He's a great choice. I'm thrilled to endorse him, and I hope that all of you join me in welcoming Julie and vote on his nomination positive.
Thank you. Any questions of the judge? Judge, I have a couple. You use the term, he doesn't beg for a continuance. Why did you use that term? I know what I took it to mean, but you can tell me what you meant by that.
Okay, so, when you are doing trial work and you're looking to lawyers and cases are scheduled every single day, people have other commitments. They don't want to start necessarily a parent protection trial that can take 6 weeks. So every day I am dealing with whiny lawyers, every single day, saying, please let me out. I need to be here. I have an obligation in the probate court. I've got to be in the district court. This guy never did that. He came in prepared. If the case was set for trial, he was ready for trial. If he couldn't be there, there was a motion that was filed that said, I have an obligation, I have a whatever. It's not, I get it. But it was the manner that he ran his law practice. That wasn't part of it.
No, I understand that. But when you say he didn't beg for continuances, I took that to mean that some lawyers must beg for continuances. Am I right? So my question is, my good colleague, former colleague, would always ask this question. Why do you care if somebody wants to continue a case? What if so it's 3, 4, 5, 6 times, as long as all the parties agree? Why do you care? Here's a guy like Kennedy who's at no, I'm being serious, who's at 3 and 4 courts maybe in a day. And, you know, he's a busy lawyer. He's not sitting home, he's not going to the beach. So when someone asks for continuance, both, there's no objection. Is there any limit as to, like, when you said big, it meant like, even if it's 3, 4, 5, 6, who cares? You're not gonna get fired, by the way.
I'll tell you why I'm here, because we're talking about kids that are pulled out of their home and they're sitting in foster. So a delay of 6 weeks, that might mean that that kid doesn't go to his home school, doesn't see his siblings, might not see his grandmother. We're talking about children that are charged with criminal offenses, and we lose jurisdiction of some of this stuff when they turn 18. So if we have a child who's charged with something serious and they are 17 and a lawyer comes in 5 times and asks for continuances, he's putting that case at risk and there might be a victim there. So that's why.
No, I get that, but my question was, I thought I said, I'm pretty sure I did, if it was a joint request. So both sides, not just him, both sides have no objection to a continuance. I mean, so. Well, that's what I'm, that was, I don't know what I'm saying is you got both sides agreeing to a continuance. With all due respect, that was my question, not just him requesting on one side. Both sides requested continuance. It's on the 3rd, 4th, 5th time. Do you care? Under my hypothetical.
Specific, so if it's something.
I get the impression that you do care, by the way. With all due respect.
I continue tons of cases for lawyers for legitimate reasons all the time. I mean, it comes up all the time. I guess my point with Attorney Young was that there's some lawyers that are never ready to go. There's always some reason not to go to trial. And he was not one of them. That's all I meant by that.
Okay, it's just another question.
It's absolutely happening. It is a, you know.
Another question. You mentioned, I think, at one point you were a bar advocate like Drew. What is your present position? A question that I ask all the people. And most people are afraid. I'm never afraid to take a stand. I'm one of those, and I don't do bar advocate work. Let me put that out there. I think the bar advocates are underpaid. I 100% support the bar advocates. I think they're underpaid. They should get paid more. And you indicated, I think, that he's in charge or supervised, did you say 800 CPCS attorneys?
Doing civil work, correct.
Okay. So I know you're not the nominee, but I'm just curious why you're here, and I do ask this question. You heard my position. I think the governor came out with a statement this week or last week. What's your position on the raises that the all the bar advocates, I should say, that they're looking to get? What's your position on that?
I think they're woefully underpaid. Thankfully, my court, I haven't faced the attorney shortage, so it's easy for me to say.
Here's one. I'm just curious now, and I won't be much longer. What if there was a shortage? What would you do? In other words, there's no lawyer, like you just said a little while ago. It's so important, these kids, this, that, everything. And there's a walkout. Your court is just like some of the district courts in Suffolk and Middlesex County. What do you do? It's real serious. You got these kids, if they're important. Do you go to CPCS and say, you got to, I mean, what do you do?
Well, I think I would start with the staff attorneys from CPCS who can still represent, who are not bar advocates. Rely on them to the extent that I can. Then it's like being at a hospital ER, you got a triage, right? So have less serious cases, then kind of, those are the children and families that can do without a lawyer in the interim until such time as we get them. And the real important cases, I'm gonna lean on friends and reliable lawyers and say, please, you've got to do something for these people. And beyond that, I, of course, would go by the guidance that the SJC has provided us.
Yeah, I don't have any more questions. With all due respect, Judge, you're doing a great job there, but that's not 100% support for the for the bar advocates, because the bar advocates needs everyone to stand up. Because if this judge is saying, oh, hey, can you handle the case? You handle the case. These poor bar advocates who can't pay rent, who can't pay their support staff, who can't pay their mortgage. If there's gonna be judges out there who say, can you handle it? You get some people from the CPCS staff, and I get some private attorneys, I think you're hurting the bar advocates. That's just my personal opinion. So that's where I come, and I don't do bar advocate work.
I just got to follow up for 1 minute.
Yes, sir.
I mean,
Councilor
I
Kennedy.
know that I said I didn't have any questions, but you hit on the bar advocate stuff that I've been very vocal about. I'm not a bar advocate either, I never have been. But I've been extremely supportive of their cause, so to speak. Now, you mentioned that you haven't had any problems with bar advocates in your court. It's my understanding from speaking to folks at CPCS that there's about to be a crisis in parts of the state with juvenile courts. Is that your understanding as well?
I haven't heard that, but it certainly wouldn't surprise me.
Yeah, well, I was told that there very soon CPCS is gonna be bringing a motion to add Essex County as well as certain counties in the dealing with the juvenile court to the Lavalley protocol. That's about to happen this week or next week, I was told. That's my understanding, but I'm surprised that you've had no issues down in Barnstable, Plymouth, but you're going to if they don't do something soon. Thank you.
Thank you, thank you. Next witness, thank you very much, appreciate your time.
Yes, Emma Knight.
Morning, how are you?
Doing well, thank you, Counselor. How are you?
Very well.
Good morning, counselors. Thank you so much for having me here today. My name is Emma Knight. I am Attorney Dawn's former supervisee in the Children and Family Law Trial Panel Support Unit at CPCS. I am here to enthusiastically support Attorney Dawn's nomination as an Associate Justice of the Juvenile Court. I first met Attorney Dawn when I interviewed for a brand new position in his unit about 3 years ago, paralegal data coordinator. I was still an undergraduate at the time, and like many other early career professionals entering a competitive and high stakes field like law, I wondered whether I could truly make a difference. I often describe my first postgraduate job, and most importantly, my supervision from Attorney Dawn, as perfect. My primary job responsibilities included conducting data-driven research projects on the child welfare system and the capital panel needs. I managed continuing legal education requirements for the panel, and I coordinated the performance review process. As I expressed interest in learning more beyond my role, Attorney Dawn created opportunities for me to watch court proceedings, to join client visits, and to attend attorney-oriented training so I could learn more and get more and more passionate about the subject matter. Over the course of 2 years, Attorney Dawn not only encouraged me to believe that I could contribute to the legal field, but he facilitated opportunities for me to make meaningful contributions as a paralegal. I never expected to feel like I could lead my own projects or suggest solutions to complex problems in my first postgraduate job, but Attorney Dawn and his team created an environment where my insights were truly valued. Our team was fairly small in comparison to the 750 to 800 private attorneys that we supported, and we faced very high stress situations, including a counsel shortage crisis, especially in the Western counties. Throughout it all, my colleagues and I had everything we needed to do our jobs well, and we took pride in the work that we did together. Attorney Dawn's deep appreciation for and relationships with the bar created a culture of respect within our unit that allowed us to develop creative solutions to challenges that the bar faced. At all levels, juvenile court work is complex and weighty. With Attorney Dawn's ample experience that we heard about in the juvenile legal field, his supervision style emphasized collaboration, balance, and humility that practitioners need in order to have sustainable careers in this field. Though he might make jokes to the contrary, I genuinely look forward to our weekly team meetings and our one-on-one supervision as opportunities to catch up, learn together, and contribute. When I look for future offices throughout my career, I'll always compare them to the trial panel support unit as the model for a perfect work environment. Toward the end of my second year at CPCS, I decided to join AmeriCorps for a year, hoping to explore a decent field and deepen the client-facing skills that I admired in Attorney Dawn and our private bar colleagues. Last week, I completed my year of service at the Community Dispute Settlement Center in Cambridge, Mass, where I had the opportunity to mediate harassment prevention order cases in juvenile court, teach conflict skills to youth and diversion programs, and more. In a month, I'll be starting law school at NYU, where I hope to take the next steps. Where I hope to take the next steps toward a career representing kids and parents in the juvenile court. My future in the legal field remains shaped by my time working with Andrew Don, and I'm confident that the same support, collaboration, and humility that he offered me will be felt by the kids, parents, court personnel, and attorneys that he works with in the juvenile court. For all these reasons and more, I wholeheartedly support his nomination. Thank you so much.
Thank you very much, Councilor Dolan.
Thank you so much for your insights, and thank you very much for saying what you said at the end. I was going to ask you if you're planning to become an attorney. I'm so glad to hear you're going to law school. I'm sure you'll be a wonderful attorney. I appreciate what you do.
Thank you so much, Counselor.
I just wanted to add a comment. Same. I'm an NYU alum. So
excited.
congratulations. It's a great law school. I did not go to law school there. I got my graduate degree in business there. I hope you'll think about coming back to Massachusetts after. But thank you for your testimony. I appreciated all that you shared.
Thank you, Counselor.
Yeah, no questions. Thank you for your testimony. You did a great job, and there's not many schools like NYU. You're going to a great law school. Good luck.
Thank you so much, Counselor.
Thank you. At this point, that will conclude the people who are speaking on your behalf. Is there anyone here who would like to speak in opposition? Then, being no one in opposition, you have the floor, and if you can tell us why you think you'd be a good addition to the juvenile court.
Thank you very much, Councilor Iannella, and thank you all members of the Governor's Council. I'm humbled and energized to be here before you this morning as a nominee for the Associate Justice of the Juvenile Court and for the honor of requesting for your support. I appreciate your time and interest in me as a nominee and for the conversations that you've had with me. I want to thank Governor Healy and Lieutenant Governor Driscoll, and to thank Chief Counsel Jesse Boodoo, former Chief Counsel Paige Scott Reed, and Deputy Legal Counsel Dara Kesselheim for their time and support for me. I would like to thank Sonia Altamirano and her team for their gracious help, and I would of course also like to thank the Judicial Nomination Commission. I also want to thank my witnesses, the Honorable Linda Sable and Emma Knight, for taking their valuable time and testifying and for their endorsement. Judge Sable first encouraged me to think that being a juvenile court judge was possible and has supported me throughout this process. So thank you. As you just saw, the future of juvenile court seems bright with the possibility of such smart and dedicated and creative advocates for children and families as Emma Knight already is and will continue to grow to be as she pursues her law degree. I also want to thank CPCS Chief Counsel Anthony Benedetti and Chief Justice Dana Gershengorn for their support, as well, of course, to thank my family. My wife, Heather, who is an outstanding first grade teacher in Situate Public Schools, her father, John, who lives with us, who's also a retired public school teacher, my son, Andrew, who works in baseball, and his wife, Noelle, who are making me a first-time grandparent in December, my son Joshua is an investment advisor, and his partner Sarah in public relations, who are starting out and working hard. My daughter Chloe, who's working in physical therapy and working on her prerequisites for medical school. For my twins, Mary and Noah, who are here this morning and who are about to start college at UMass Amherst and FSU in just a few weeks. I'm deeply indebted to them for their love, their support, and just the right amount of humorous irreverence about their old man. I grew up in Southern New Jersey. My mother, Barbara, was an administrative assistant and a fundraiser for our local hospital. My father, Andy, was a salesman of cranes and excavators, as well as garage doors. My mother's second husband, Rich, was a city manager. My engagement with families began when I was an undergraduate at Boston College, and I was able to use my work-study allotment to begin to work with what was then New England Home for Little Wanderers, their Orchard Home program in Watertown. I was working nearly full-time from Friday afternoon to Sunday evenings with adolescents in what was then DSS custody. I continued in that work at the Night Children's Center in Jamaica Plain, where I met my wife, and then also at the Granite House program in Quincy, which was a residential for DMH kids. I was there, worked as a direct care worker and as well as a supervisor. As we all know, residential treatment can be very difficult. A child is removed from their family with trauma and issues, and then they're living amidst other children with trauma and often behavioral issues. And that child can feel overwhelmed, alone, and defined by their family circumstances that they've had no control or responsibility for, but that they are bearing the consequences. During that time, I noticed that those children who had lawyers that were involved and advocated for them had their cases move more quickly, and that their time in residential treatment was brief, and they were able to be either reunified with their families or in some instances adopted. This led me to go to law school to do care and protection work specifically. Before attending law school, I also lived at the Haley House Soup Kitchen in the South End and worked with unhoused men as well as with men and women on the street in Boston through the Pine Street Inn outreach van program. In listening to those men and women and their stories of how they ended up struggling with substance abuse disorder, mental health, and being on the street, an all too common thread in those stories was their time in foster homes and group homes while they had been in DSS custody. While engaged in the practice of law, I've had the privilege of working at the Children's Law Center in Lynn, the Youth Advocacy Project in Roxbury as doing delinquency, as well as CPCS staff office up in Salem, but also as a solo practitioner, as a bar advocate for nearly 20 years. I'm intimately familiar and sympathetic with the struggles and challenges that solo practitioners face. During those 20 years, I've been a mentor to many new trial attorneys doing CAFL work. For 15 years, as Judge Sable mentioned, I was the resource attorney for Norfolk County in CAFL cases for about 11 years, and having the privilege of being someone that attorneys would come to help them strategize, to perhaps give advice about experts and things, motions, and also I had the opportunity to work with court personnel and to address issues of local practice. At the same time, I also engaged in appellate work for CAFL cases for over 10 years. I think that combination of trial and appellate work has given me a nearly unique perspective about being a judge in juvenile court. However, most recently in trial, as part of the trial panel director for the Children and Family Law Division, I've had the privilege of working with incredibly smart, committed, and empathic colleagues, some of whom are here today in my unit, as well as the many 750 private attorneys around the Commonwealth that engage in our work. The thing that's notable, I think, about juvenile court is that it's perhaps uniquely collaborative while still maintaining the system of justice that's been carefully constructed and developed in Massachusetts. The work of families to improve their lives as they come before juvenile court, the work of the attorneys advocating for them, the work of the agencies and their caseworkers, the work of the court officers, the probation officers and clerks is inspiring in their shared dedication to the families that appear in the juvenile court. It is my commitment that if you confirm my nomination, that I will continue this vital work with energy and dedication. Thank you.
Thank you very much. Councilor Ziegler, any questions?
Yes, thank you. Thank you, Mr. Adon. It was a pleasure speaking with you a few short days ago, and congratulations on your nomination. So during our conversation, we talked about your passion for youth advocacy, and you spoke so eloquently in your statement about that. We also talked about what's needed in the juvenile court in order to strengthen their ability to support and provide for the clients that are coming through the doors. Can you speak a little bit more to that? I think your response to my question around that was very valuable. You talked about wanting to ensure that there's accountability within the courtroom and how you would do that with compassion. So I just wanted to give you some time to speak about that in a public record.
Thank you. Yes, as everybody knows and has said, obviously the work of the juvenile court is very, very important in trying to support children and families. And the accountability, I think, comes in trying to identify issues that are barriers for families and coming up with solutions to address those issues in as quick a manner as possible to help a family move forward and out of the juvenile court.
Thank you. So we know that also another issue sometimes may be with the caseload and the caseload scheduling and just the efficiency around how we navigate that throughout the courts. How would you from the bench look to affect that?
Caseload management efficiency. Well, fortunately, there's been a new set of juvenile court rules that have just been promulgated that give a lot of guidance and helpful guidance about trying to give structure and timeframes for helping the cases to be efficient. So I would certainly abide by that, but as Judge Sable mentioned, and as Attorney Counselor Ionella, forgive me, also brought up, things come up. And so to be attentive and respectful of parties when they're asking for a continuance for good reason that's agreed upon, to try and balance both the need for efficiency and timeframes, but also the needs of each and every particular case that comes before you. I think you have to be very attentive to each of those parties that come before you in the juvenile court.
For sure. And during our conversation, we talked about especially how trauma is intertwined within each and every one of those cases, right? Essentially, everyone who's walking within the door has some sort of trauma, whether your trauma just being in society, just being within the courtroom space, or the case by which is being brought before the bench is what is promulgating that trauma. How would you apply your trauma-informed lens in order to reduce some of that anxiety that may be felt entering the courtroom?
Yes. So in the work that I've done prior to going to law school, working with traumatized children and families for over a decade, I certainly have a deep appreciation and understanding of trauma and what it looks like. Also in the 20 years of practicing in the juvenile court, I'm very familiar with what trauma can look like in a courtroom. And so I think being attentive to what trauma looks like and giving parties, a parent, say, for instance, who's overwhelmed or having a trauma response, an opportunity to take a break, to meet with their attorney and give them a moment to be able to figure out how they want to go forward, to present their case in the best way possible, in each particular circumstance.
One of the things that I find refreshing about your experience is your experience with individuals who are housing insecure, from college days up throughout your career. And we know that within the juvenile court, many of the cases that come before the bench have touches of housing insecurity laced within them. Right? How would you use your experience and your knowledge about housing insecurity and how it affects families in order to take a different approach to how you are, how you're overseeing cases?
I think one of the primary ways that this can show up is in the instances where a parent temporarily loses custody of a child, that can destabilize that parent's housing circumstance. They may lose their housing. Like say, for instance, say a father has a 2-bedroom apartment that he resides in with his child. The loss of that child to DCF custody can cause that father to lose their housing. It's a really difficult problem. I think some of the solutions of those things exist outside of the purview of the judge in a juvenile court. But I think the other thing is that it's really important, I think, and something I would strive to do is as a juvenile court judge to know the resources in the community in which you're serving. So to know what the housing and which housing authorities or programs are available in the local community. So to try and steer and be a part of the steering of the parents to that resource.
Thank you. I appreciate that. And I bring that up in our conversation prior and now, because we're seeing a rise in housing insecurity across the state, across this nation, if you will. And so from the bench, that may be something that is, that's part of majority of your cases, if not all of your cases. So to me, it's very important that someone sitting on the bench has a good understanding of the sensitivity, but also is looking at being creative, because we're just going to be seeing a lot of individuals who will need that support. So I thank you for that. I thank you for your time that you took to answer questions that I had prior to today, and for your thoughtfulness and your approach to answering my questions. Congratulations again on your nomination, and I do, hope for your success in this venture.
Thank you very much. Councilor Terrence Kennedy.
Good morning.
You were in charge of 750 bar advocates?
Well, let me,
Using a different term, private attorneys.
private attorney.
You paid the same.
Right,
Under the CPCS.
as private, overseeing and supporting them, not in charge of directly, because they're private attorneys, not
Exactly, I
a.
understand.
Okay,
With a supervisor, so to speak, of the,
sure. Of the CAFL attorneys, yes.
they underpaid?
Yes, woefully, yes, absolutely. They deserve an increase.
You know, one of the things that, out of those 750 that you're supervising, have any of them stopped taking cases?
Obviously, I couldn't speak to each and every one of them.
We just know we're having shortages because of that. You got the whole state, right, for that?
Yes, that's correct.
There's a lot more than 750 private attorneys at bar advocates.
Absolutely.
You're just talking about the juvenile court.
And even really just children and family law, that doesn't.
You wouldn't see that part of it, I get it, not necessarily delinquents.
Right.
Now, they, have, statewide, have you lost people taking cases? Have they stopped taking cases in different areas?
I think it's happened like this. We have had a shortage of attorneys in CAFL cases, particularly acutely in the western part of the state. I think that the pay,
That's been going on for years.
it has. And so that the pay issue, it hurts, I think, with retention of attorneys, but I think even more significantly, perhaps, is newer attorneys, we're not getting them. And so that the
We're
low.
not getting some experienced attorneys that'll leave,
Yeah, that's correct.
which you need too.
Absolutely.
Now, now I've read in the paper a lot, different comments from various legislators saying that they're kind of shocked, or they weren't aware of this problem, that it was an issue of pay. From what I understand, with my discussions with Anthony Benedetti, he's been raising this issue for years.
That is my understanding as well. We get updates that CPCS provides to the whole private bar about their advocacy year to year.
I actually saw a transcript from a Ways and Means hearing, where he testified that they were so short in some areas because of the poor pay, that it was gonna reach a crisis point if the legislature didn't do anything. Do you think we hit that crisis point you talked about 2 years ago?
Yes, I think we're there.
So why is everybody so surprised, do you think, that all of a sudden this came out of nowhere? One person was quoting saying, we only heard about this a mere 2 weeks ago.
I couldn't answer to why someone would say that, but it's surprising because it's a constant issue, and I know it's a constant point of advocacy for Chief Counsel Anthony Benedetti and General Counsel Lisa Hewitt.
I understand that. I've never done bar advocate work, but they've had a lot of, especially in the district court, and Superior Court, Suffolk Superior has had a lot of problems with, long before this so-called walkout or movement or whatever you want to call it happened, that they couldn't fill duty days in a lot of courts for a long time. Is that your understanding?
I can only speak about what I know, which is the CAFL portion, so I don't really know about the status of duty.
Kind of high up at the CPCS ranks at this point, right?
Middle, yeah, I'm a middle manager.
So I assume you guys talk to each other.
Well, yeah, I mean, I'm embarrassed to confess you'd be surprised a little bit. You'd be surprised a little bit. We are sort of siloed a little bit in our, CAFL does CAFL work, and we actually I don't have the opportunity.
Talking to each other, you should, but.
Yeah, I don't disagree with that, but
But
we
the, But, you know, you've certainly heard from your colleagues that there are issues in other parts of the states, and
Absolutely.
that's been ongoing for a very long time.
And it's been, it's been increasing in intensity over a period of years. You know, people that do the work it's an aging bar.
Till it blew up.
Yes.
3 months ago, right?
Yes,
It's been brewing a long, long time.
it has.
That's why I'm so puzzled why people are shocked. You ever see the movie Casablanca? Yeah, I'm in Casablanca, I'm shocked. Famous line, right?
Right.
That's how I feel about this. All of a sudden, everybody's shocked that there's a problem with the bar advocates.
It's a serious issue, and I know that the chief counsel,
What's everybody digging their heels in?
I would imagine you are far more sophisticated in your analysis of those situations than I am.
This particular situation, I don't understand it. I don't know why people aren't just fixing it. That's what we in government are supposed to be doing, is fixing it. This is a big problem. I just don't understand why they're not fixing it. But eventually they will, because it's only gonna get worse. We had a long talk on the phone. You've answered all my questions. Not even close in terms of being qualified. You're way over the top, so I'll be voting for you next week.
Thank you. I appreciate that, Council.
Councilor DePaul.
Thank you, Counselor. Good morning.
Good morning.
Congrats on your nomination. I appreciated your opening statement and your witnesses.
Thank
You spoke to things we want to see in the juvenile court. I'd like to ask you a little bit about CRAs.
Yes.
So for those who may not know, they're children requiring assistance.
Yes.
Some people remember them as chins. And correct me here, but
That's us old people.
I didn't want to say so. Our elders. So to oversimplify, children requiring assistance can be referred to the courts, for example, by school districts or by parents who aren't sure where to turn.
Yes.
Is that fair to say?
Yes.
So over the last 2 years, according to the Boston Globe, there's been a 17% increase in CRA referrals for children from 6 to 12. As someone in this field, why do you think that's happening?
Well, I think that there's certainly, I think COVID certainly has played a role in that and has exacerbated some of the issues that children and families face. And so that we're still seeing the fruit of that, of that circumstance. I think there's issues of under resources for families and children in the Commonwealth, particularly around mental health issues. It's well known that there's very long waiting lists for these kinds of services. And I think that they have someone has told them along the way that if you go to court, you'll get additional assistance with those issues.
Yeah, interesting you raise that. I'm fortunate to be relatively privileged, and it's impossible to find mental health care for my children. There's pending legislation in the legislature to bar referrals of CRAs under the age of 12. Do you think that would be a good change?
I mean, obviously something like that's up to the legislature for sure. And I think what that makes me think of is really the really excellent work that's being done by family resource centers that have been developed across the Commonwealth and are continuing to develop and are spreading to more and more locations. And that they have really done great work in trying to be a clearinghouse for a family, for them to be able to come and get these kinds of referrals that they need without having to go to court, which, as was referenced already, can be traumatic for a child or a family.
So it would keep these 6 to 12-year-olds outside of the trauma.
That would be the hope.
I want to ask also about schools, which are also increasing their CRA referrals. And I'm a former educator and special educator, and I've worked with court-involved kids in alternative school placements. So why do you think we're seeing increased CRA referrals from schools? I know COVID, we'll get that out of the way, the shadow of COVID, but I think it's more than that.
Sure. I mean, in fairness, I think really each school district really is they function quite differently. I've done plenty of education work on behalf of clients, and there are some school districts that are incredibly receptive and cooperative and collaborative in trying to help address needs. There's other ones that it's a little bit more
Could
difficult.
I pause you for a second? When you say you've done education work, you've counseled on, for example, acquiring or seeking special ed services, IEPs, et cetera?
Yes, the case I just had 2 months ago, I, had a psychological expert and got oh my gosh, IEP just rewritten
Yeah.
on the basis of that.
So having been an educator and seeing that, and I've written IEPs,
Sure.
and having been an attorney and done pro bono work with children, boy, the mood changes when a lawyer walks in the room. From the educator's perspective, I felt like I was an advocate against some of the school districts I worked in who were actively seeking paths. How can we avoid diagnosing the student, testing the student, and getting a diagnosis? Do you think that there's disparities around access to special education services by socioeconomic status or race in this state?
I think that can be reflected by how a school district may feel overwhelmed by the needs that they are dealing with. As you well know, school districts are often the main point where many sort of issues kind of come together and a lot of needs come together, and schools, while they're equipped to do many things, can't meet all the needs. So as you, I'm sure, know, that schools that have predominantly challenges with socioeconomic populations, that meeting those needs can overwhelm a school district. So often funding and resources is, at the heart of many of these things.
I've had concerns in my experience with the information that school districts sometimes bring to the court that's lacking context. Someone who doesn't know the child is speaking to situations they are not privy to. As a judge, honestly, every time I've been there in the courtroom supporting a student, as a judge, how do you begin to address that issue?
Well, I think you seek to, you listen to what the school district is telling you. There are instances where you can ask some follow-up questions to unpack maybe some of the things that they're saying. As you know, can be a very jargon-filled field. And so to have a little bit further explanation, but also I think it's really very important to listen to the child through their attorney, and also to your probation officers who can provide more context than what's being initially presented.
Schools are usually referring a child for truancy or for discipline. Is that generally true?
Sure, yes.
And when we're seeing behavior that results in those two things, it's likely due to a lack of educational resources and other support services. Black and Latino students over the last couple of years are still 3.5 times more likely to be referred as children requiring assistance by their school districts than white students. It just seems like all these things become exacerbated. And I'm glad to see that someone with the perspective to think about these things is going to be joining the bench with our other outstanding juvenile judges. I have one more question. Have you seen, to your knowledge in the field, has there been an increase in truancy reports since the mood around immigration enforcement in this country has changed?
I personally have not seen the data to correlate that. The data may be out there, but I myself have not actually seen that.
Completely anecdotally, speaking with educators, they're seeing Latino students in particular missing school for fear of whatever, being apprehended on their way to school, as a student in Milford was, whatever the case may be. Thank you for your time, Counselor. Thank you for your time. And Counselor, I want to say, I was listening. I apologize for being late for the hearing. 2 hours is no longer a valid estimate from Worcester. This is the summer, so this started in the spring. Okay. So, but I was listening to you two, and I really appreciated, Counselor, the comments you were making about the bar advocate issue. So thank you.
Thank you very much. Counselor Jacobs.
Good to see you. I don't have a ton of questions. We talked at length and I really appreciate getting to know you and all the many different areas we delved into and hearing your perspective on it. One conversation that we had last night that I kind of wanted to bring into the room and elaborate on and give you an opportunity to talk about, multi-pronged, but the relationship between juvenile court and probate and family and where it is now and where you see that evolving in service to the well-being of children and families. And I'm just gonna put it out there now before I forget, but the second question, out of that, we talked a little bit about, a specialty court that I believe started in Franklin County in the probate court, the family-based drug court, which has evolved. The name has changed over time. I think today it's called the Wellness Court. But it's a court that really holistically involves the identified addicted patient, but also all of the family dynamics and family systems. If both parents have an addiction problem, if one has an addiction problem, the grandparents, the children, it's a very collaborative with community resources approach to bringing all the wraparound services to play with accountability to the person who is identified in the court, but really not leaving any member of the family behind in the treatment of and the healing of the situation. It's an approach that to me makes so much sense beyond probate. Obviously in probate and family makes a ton of sense, but juvenile court is a place where it makes sense to me. District court even is a place where it makes sense to me, just in terms of identifying, you know, the symptomology of what our justice system sees and why. So those are, I'm sorry to give you so much in a bundle, but but those are the two areas that I really wanted to hear from you on.
Thank you, Councilor Figurs. With regard to probate court, Chief Justice Gershengorn behind you has done a lot of work working with the probate and family court to work out a memorandum of understanding to help facilitate the more rapid resolution of cases which require parties going to the probate and family court in order to get an underlying order, and as well in some other areas. So I think that's really a great and exciting development, and I think that will help to expedite a lot of cases. I'm not sure if that memorandum has become public yet, but my understanding is it's about to be. And so Chief Justice Gershengorn has shown a lot of leadership and gotten that done, which is really important. The other thing in juvenile court called the Family Treatment Court, Judge Shaw out in Springfield has done a really great job initiating and pioneering the family treatment court out in Springfield. And for all the reasons that you sort of mentioned there, again, Chief Justice Gershengorn has worked very hard and very collaboratively with CPCS and other stakeholders in the juvenile court to figure out a model that will work moving across what will hopefully end up being the whole Commonwealth. But again, Chief Justice Gershengorn has shown a lot of leadership with that. So I thank you for setting me up for that in front of Chief Justice Gershengorn. But it's true. There's been a lot of exciting work.
No, I appreciate, I think that's a good forward direction, that I'm really happy to see the courts take. To build on some of the racial disparity conversations that have already been had in the room, we talked a little bit about, on the care and protection side, the racial disparities in there that is, you know, a longstanding trend. I want to put it to you, if assuming you're on the bench and are you know in a court where those disparities are clear, what if anything can a judge do to be an intersection or you know play a role in shifting some of the trends towards, you know, outcomes that become more racially fair? Is there anything from the bench that one can do if those trends are in play in your community?
I think one of the really important roles that a juvenile court judge can play is around the issue of plans. The the department and the court, the Department of Children and Families is required to have a plan in working with a family, an action plan or a permanency plan. And that I think one of the things that the judge has to do is to ensure that those plans are meaningful and that they're addressing the actual needs of each particular family in a particular way. And I think that that would be something that I would look to focus on.
Well, to be more specific, and we touched on it last night, but in the event that in terms of seeking temporary guardianship or placement, the recommended route is foster over family members for reasons that may also have to do with the racial disparities in our justice system, the over policing of marginalized communities. Family members may have a record for reasons that aren't reflective of the quality and care that they would provide to a family member that they love and have a bond with. What, if anything, can a judge do if the recommendation from DCF is to remove to foster when there are willing and suitable, but possibly also impacted by, the disparities in our justice system? What can a judge do?
So every party has the right to put forward it's called third-party custodian, and that often is kinship placements or family members. We don't need to use the jargon, sorry, just family members. And so oftentimes they have there can be a disproportionate presence of Corys sometimes. And so to evaluate those with the assistance of the attorneys that are presenting that person, giving you the information, home studies that can be done by probation officers or through a court investigator, perhaps later in the matter, to help evaluate the appropriateness and safety of that placement. I think that's a very important option to address the issues that you raised.
Appreciate that. Listen, I've enjoyed getting to know you. I've enjoyed the conversations that we've had. I don't have any more questions today, but thank you for answering the ones that I did have. So.
Thank you for your time.
Thank you. Counselor Tamisha Civil.
Good morning, Counselor Civil.
Nomination.
Thank you.
I know we talked at length about your experiences and your advocacy. If you can speak on your trip to Tanzania and how did that shape the way that you think and practice when dealing with juveniles?
Sure. Yeah. So I had the opportunity to go spend 4 or 5 months in Tanzania and working at what was functionally a shelter and a program for what were AIDS orphans at the time in Tanzania, so that there was children that were on the street, and so trying to provide services there and have the opportunity to work with staff to figure out ways of disciplining and engaging children in the program, beyond sort of corporal punishment, which had been sort of a cultural issue in that situation. The thing that was that I really took away from there was that there was a bit more of a child's rights focus. In Tanzania, we have more of a child welfare kind of model here. And so ensuring the commitment to and ensuring the engagement of the child in every step of the process has certainly shaped my practice as an attorney, for sure.
In your opinion, what role does community involvement play in preventing youth from entering the criminal justice system?
I think it's vital, right? One of the things that's so important for, I think, every child, no matter the mode that they happen to come in front of the juvenile court, is engaging them with a community of some sort, whether that's arts or whatever it is, that they be engaged with the community. And so I think it's important for a judge in the juvenile court especially to know the community that they are serving in and to know the resources and the possibilities for those engagements. It's central and vital.
Can you give some examples of when you actually petitioned for a juvenile to be part of the get resources or access to a particular program?
Sure. So for me, it didn't happen primarily through petitioning. It kind of happens in your advocacy outside of the courtroom. Maybe suggesting something to, or working with the DCF, social worker, or, yeah, that's usually, or taking steps yourself to try and, make a connection for a child in the community. There's many great programs, similar to like Big Brothers and Big Sisters, or other more specialized programs that can make a real important difference for a child to be engaged with their community, and so to try and help them engage that.
Been part of any organizations that deal with protecting or helping juveniles to, like, ROCA program, or just any other program that you've been part of to understand the culture of to which of this child is part of?
Well, no, I wouldn't say a community program per se, but working in the residential treatment programs that I worked in, which were based in local communities and served their local communities and the families there. I think that was certainly one of the things that happened. Well, in the different programs in the different places, forgive me, as well as, at Pine Street Inn and Haley House. Haley House is a great example of a, so I guess I take it back. I was involved with Haley House. Yeah, so, so thank you. So at Haley House, it's a great example of a community-based program that served homeless men, unhoused men, as well as the elderly in the South End for many, over 50 years now. And to have lived there and worked there, yes, and it makes a huge difference. So, thank you.
Thank you very much. Counselor Dolan.
I'll be brief. I know we've got another nominee coming up, and Counselor Ionel still has questions for you. I know Anthony Benedetti speaks very highly of you and that he's going to miss you. I was already impressed with you, but I was very glad to hear from Judge Sable that clerks are happy to see you. That speaks very well of you. I don't really have any questions. Just want to point out a few things that really impressed me, in addition to your knowledge, your depth of knowledge on the law. But the fact that you've done so much work with homeless people speaks of your character, and also the fact that you were able to benefit from the wisdom that they provide, which I think will help make you the extraordinary judge that I think you're going to be. And also specifically want to thank you. I'm sorry, I didn't expect this. You had a client you told me about who didn't go to high school because they didn't feel safe. And you were able to recognize that. I was once a child who didn't go to high school because I was being bullied so badly that I didn't feel safe. Wow, I'm sorry. Thank you. That's exactly the quality I want the juvenile court judge. I'll vote for you. Thank you.
Thank you, Councilor Dolan.
Thank you very much, Counselor. I don't have many questions. We had a nice conversation. We've heard this gentleman, I've never met him, Anthony Benedetti. I don't know. Like I said, I don't do bar advocate work. I won't hop on it. I actually saw it on TV. Okay. NBC, Channel 7. It was 7 o'clock. It was about 2 or 3 weeks ago. It was a half-hour show. They're talking about the bar advocates. And I thought it said the bar advocates make $65 an hour. And this was shocking to me. Anthony Benedetti, are you kidding me? Listen to this one. Was recommending to the legislature a raise to $73. That's an $8 raise. Are you kidding me? Are you kidding me? I don't know about you, but I'm not gonna put you on the spot, but I probably will. 70, an increase from 65 to 73. It's nowhere near what these neighboring states get. What's your feeling about an increase to $73? I think it's awful. I think it's pathetic.
I understand. I'm not at the level clearly that Chief Counsel Benedetti is in these kinds of negotiations and dealing with.
Not either. I just saw it on TV.
Oh, right. So I know that he's very committed to just trying to keep the rate increasing, even if it's in a particular year, what may seem like a small amount, but every year to try and keeping it increasing. Yeah, I know he's not always successful in that. I agree with you for sure that a rate increase that is substantial at some point is going to be necessary to attract new and keep new attorneys like Emma Knight coming to work in our Commonwealth, and we desperately need them, as well as Councilor Kennedy had said, to retain the wisdom of our seasoned practitioners.
I get it, but I gotta tell you, I've never met Anthony Benedetti. When it comes to supporting the bar advocates, I wouldn't give him a high grade. I mean, wait, how long has he been in that position? About,
Uh,
yeah, a year, 5 years?
Oh, no, right, I'm
Time.
20, maybe 20 years or so.
Time. He hasn't, you wouldn't give him a high grade as when it comes to working with the legislature and giving the bar advocates the amount of money that they deserve. I mean, I don't know. When I saw that, I was like, are you kidding me? If I was a bar advocate, I would have called the guy up on the phone, but I'm not. But you know what? The council has asked a lot of good questions, but to me, what makes my whole decision so easy is when I see Bay State Community Service, the Granite House, North Cambridge Catholic High School, theology teacher, New England Home for Little Wanderers near my home in Jamaica Plain, Tanzania, the Haley House, Pine Street. You know what? I don't have to ask you a question. You are one hell of a decent person. To have this kind of record, yeah, you had Judge Sable. She did a great job. I didn't mean to give her a hard time, but strong advocate. I got your name. Emma Knight, great job, but there it is right there. You're a decent human being. That tells me everything. I think you're gonna be a super, not a great, but a super addition to the juvenile court, and I'd be more than happy to support you next week when your names comes before the council.
Thank you, Councilor.
Thank you. That will conclude the hearing. And thank everyone for coming here. We have a hearing in about 3 minutes, and we don't want to kick you out that quickly, but.
Stage here and then we come up.
It's too hot. It's noisy out there, we'll close it. Hey, Aaron. All right. I am going to start by reading a letter from the governor dated July 2nd, 2025. The Executive Council. Dear councilors, don't worry, I'm loud enough. I am pleased to nominate Lisa S. Cord to the position of Associate Justice of the District Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I've been closing the nominee's resume for your convenience. Sincerely, Maura T. Healy. Wow, that's pretty cool, huh? I'll give you my copy before you leave. Frame it or something like that. Okay. I'm going to start by introducing the councilors. Right now, we have Councilor Mara Dolan in the room, and we have Councilor Eunice Ziegler in the room. Everybody else, we just finished the council. They're probably in the bathroom, so we'll introduce them when they come back. All right. We're going to start by having you introduce everybody you have here. Oh, except for Cheryl. Come on in. You can come in. Sit down over there. My favorite JNC member.
I guess we could start over there. Kuru Verma.
Right, go ahead.
And I'm Richard, Judge White, my dad is in, my son Wyatt, my mom, Eileen. This is the easy part. Janelle, who's associate priest in church parish of the Epiphany. My best friend Allison, and my other best friend and husband David. I think that's.
All right, we got everybody?
Yes.
All right. I'm going to introduce, when the other councils come in, I'll introduce them as they come in. And we are going to start with your first witness, the Honorable Asher White. He spends more time up here lately than we do. And do not forget the most important law of the land, Judge.
What is that, Councilor?
Liberty.
Yes. You have reminded me of that several times in my career. I want to say good morning to everyone. It's always a pleasure to be here and see all the councilors, and it's an honor today to speak on behalf of Attorney Lisa Cord. I will try to be succinct and take any questions that you have. First, how I met Attorney Cord. I met her in 2023 when I began sitting in the Woburn District Court. In a 2-year time frame, she appeared in front of me hundreds of times on arraignments, motions, trials, and I can safely say she will make a fantastic district court judge. In terms of background, as many of you know, before I went to the Superior Court, I was the first justice of the Woburn District Court, and I sat there for about a year before I became the first justice. The first thing I heard from everyone, including Marianne Hinkle, who was the previous first justice when I was coming over to Woburn, is not only does Woburn have excellent court staff, but has an excellent group of bar advocates, an excellent bar. That's what everybody would tell me. And certainly you've been able to see that not only Attorney Cord has been nominated, but Judge Polly Phillips, who came from the Woburn District Court. So we had a really good group of bar advocates. Even amongst that excellent group, probably the best overall I've seen, Attorney Cord stood out amongst that very good group. And she stood out for her preparedness, intellect, and and temperament. In terms of her preparedness, she was always ready on her cases with a very busy caseload. She's not only ready to make an argument in front of you, but if you don't like the first argument, she's ready with alternative arguments. And that is who she is. That shows the level of readiness she has before she stands up on any case. And honestly, that's what makes an attorney special, when they have layered, multi-tiered arguments to make before a judge. That takes time to think through that. That is the sort of care that judges need to have when they make decisions, especially on very difficult cases. And Councilor Jacobs and Councilor DePaulo, good morning to you. Good to see you again.
You don't have to introduce them now. You just.
In terms of her intellect, she's both smart and intelligent. Intelligent because she has great intellect. She was one of those attorneys that I could question. A lot of attorneys think when you question them that you don't like them. It is the total opposite. You question lawyers, you know, that can handle it. And the more respect I have for a lawyer, the more I question that lawyer, because I know they're ready to respond. And she was always very thoughtful in her responses. The district court is underrated for the complexity that it brings. It does have complex cases, and you need people with the kind of intellectual curiosity who think about larger societal issues and think through the case like Attorney Core does. But she's not just intelligent, she's also smart, meaning she knows the shortest distance between 2 points. So as a lawyer, she knew when to strike, when to parry, right? That sort of good judgment you can figure out that carries over to being a judge. You can figure out how much a case is worth. Most cases in the district court settle before trial in some way, and judges have to have good judgment, understanding what case is worthy of a dismissal, probation, or the potential for incarceration. And in terms of her temperament, she always had a wonderful attitude. I remember there was a specific client who had a serious mental health issue, an issue of competence. And I remember that person didn't want to accept an attorney. And I appointed Attorney Core, and I told that particular defendant to try and work with Attorney Core as best as possible, because I think you will be surprised. That defendant came back and listened to everything Attorney Core said and swore by her by the end of the case. And I think that speaks to how good she was interacting with people. We already at that time had a shortage of bar advocates, and Attorney Core would be in the audience when we wouldn't have a lawyer for a person. And when I was a lawyer and I saw a judge looking at me, I would try to make my way out of the room knowing what was about to be asked of me.
Some lawyers still do that.
Yes, and I don't knock them because they want to get out of the courthouse. Attorney Core would stand up knowing what I was going to ask and volunteer to take the case over and over and over again. We imposed that burden on her, and every time she accepted without any pushback. That attitude matters because the quality of being a good colleague matters when you are a judge. It's an underrated quality. How are you going to help your colleagues and the court staff when we're short on sessions? We need someone to have a mental health hearing, someone to run over and take some extra work. That's the sort of attitude of that judge who's going to be willing to do that. Lastly, I do want to mention her experience. I think her experience is perfect for the district court. I'm biased because she and I have a very similar resume, but it is perfect for the district court. She was a DA for several years. I think was it 7 years? Or about 6, 7 years as a DA, as you know, in court every day with judges breathing down your throat.
Be Judge Nestorada this
being in court becomes second nature when you have that much experience. She did civil for a period of time. The district court has a large civil docket that people often overlook, so she'll be able to jump right into that session. And I do want to mention she was a bar advocate for the last several years. And as a bar advocate, you have indigent clients. You deal with people that society has forgotten and has often scorned. And you have to go down to a jail cell with a person who not only has had a very difficult life, but is having the worst day of that very difficult life. And you have to go down to that lockup cell and say, "Hi, I'm Lisa Poor, and I'm here to help you." That is not easy to do day after day after day with very little fanfare and very few thank yous. And Attorney Core did that every day extraordinarily well. That gave her not only legal experience, but empathy for others in terms of walking in the shoes of other people of other races, people of other sexual orientations, people of other gender identities. You can't necessarily fully put yourself in another person's shoes, but getting that experience certainly helps you think about those issues. The more you learn, as I think she would say, the more you realize that you don't know things, and you have to continue to learn things from other people. And she'll continue listening, and that's what judges need to do, to continue listening, continue learning, continue evolving, even as they're on the bench. So my only regret is that I won't get to sit with her in Woburn Court. Judge Chan and I were hoping we would get a chance to sit with her, and she would be a colleague with us in Woburn. But she'll have about 200 new colleagues ready to train her, so she won't need me. Right. So I enthusiastically endorse her as a nominee to the district court, and I'll take any questions if you have them.
Anybody have any questions? Well, just a comment you missed. Spent a lot of time involved and spent a lot of time in movement, and definitely missed. I'm happy that you're in Superior Court because you want to be there, but we all wish you were back in district.
I appreciate that. I miss all my friends and former colleagues in the district court, but it's been very good in the Superior Court. Unfortunately, I have to run out to Worcester to start my civil session. It's going to be the joy of a very perfect summer day.
Enjoy. Thanks for coming.
All right, thank you, everyone. Congratulations again. Thank you.
And your next witness is Attorney Benjamin Richard, prominent attorney Benjamin Richard.
Thank you, Mr. Kennedy. Good morning, counselors. It's a real pleasure and an honor to be here. I am Ben Richard. I'm an attorney with an office in Salem. And Lisa Kaur is a colleague and a friend, and I am here to enthusiastically endorse her for the position of Associate Justice of the District Court. I can tell you folks, just briefly by way of my background, I was in the District Attorney's office for about 3.5 years. I then worked for a prominent attorney in Gloucester for 2 years, 3 months, a week and 2 days, but I promise I wasn't counting. And since 2006, I've been out on my own, running my own firm as a criminal defense attorney. That's right around the time that I met Lisa when she was a new assistant DA, primarily in the Lynn District Court. When I went out on my own, I was a bar advocate and I was in Lynn. So we had cases occasionally together as adversaries. I always found Lisa to be smart, prepared, tough when she needed to be tough, but reasonable and fair, and a good prosecutor, very good prosecutor. And I think as a former prosecutor, that's a very important skill because of the imbalance of power and the resources of the state. And so I was always a fan of Lisa when she was working in that capacity. When she became a defense attorney, I think it's fair to say that she had reached out to me in sometimes a mentorship role. Good luck. But we had occasion to begin working with each other on certain cases. And I want to discuss obliquely a little bit one specific case that we had. We have a young man who was about 19 years old with significant but as yet undetected mental health issues. And unfortunately, he had an episode that culminated after all night long in a motor vehicle collision that led to a death. And it was prosecuted out in Western Mass. And Lisa worked in every capacity that a defense attorney could possibly work and beyond in crafting a resolution of this case that touched on all of the issues of the criminal justice system, punishment, deterrence, but moreover, rehabilitation for this young man. And the type of work that she did, the involvement of getting a collaboration with his mental health treatment, with forensic psychiatric evaluation, and the legwork that she did in going out to Western Mass on a number of occasions, sometimes with me, sometimes on her own, to work the case and to speak to the prosecutors, led to a non-jail sentence with the assent of the family of the decedent. That's when I realized that she was above and beyond the average. I've been practicing primarily in the district court now for 25 years. And people talk about calling balls and strikes or triage or whatever else you want to say about the district court. 10% of the cases that come in are the type of cases that should be dismissed right away. 10% of these cases are cases that really need extra attention. There's a huge middle ground that is a lot of triage and is a lot of calling balls and strikes. And Lisa's intellect and her background, I don't need to belabor it. And actually, Judge White stole a lot of my thunder. But her background, both as an appellate attorney, doing research, doing clerkships as a prosecutor, doing civil work, ticks all of those boxes. But her heart, this is going to be someone who, when those 10% of cases that require extra attention, she's going to take the time. And taking it under advisement isn't going to just mean, I don't want to say no to you right now. It's going to mean that she's really going to pay attention. I told Lisa that I think she plays tennis and other racket sports. And they say that when you play against someone better than you, it elevates your game. She is going to elevate the game of the attorneys who appear in front of her. She's going to welcome good practice. And I think she's going to be a fabulous district court judge. I couldn't recommend her more highly. And I thank you for the opportunity to address the.
Thank you, Ben. Does anybody have any questions?
Thank you.
Thank you.
Yeah, I'll just have to work on my parking, but yeah.
Kind of awkward.
Was that? Oh.
Just the way it went. I would have given her a big hug. I wouldn't have like.
No, I mean.
From the station.
Camera, so we have to, yeah.
Okay. Yeah, you know. All right, that closes the witnesses in favor of the nominee. Are there any witnesses in opposition to the nominee? You think your husband's coming up? I guess not. So we'll close that part and the floor is yours.
Good morning. I first offer my sincere gratitude to Governor Healy and Lieutenant Governor Driscoll for their faith and confidence in nominating me as an Associate Justice of the District Court. I also extend my thanks to members of the Governor's office for their guidance navigating me through this process. And thank you to each of the members of the Governor's Council. You have an important role ensuring the nominees are not only well qualified, but thoughtful, curious, and willing to question their own assumptions. Thank you for the time you spent reviewing my application and for learning about me. It's a tremendous privilege to sit here before you, and I appreciate the conversations we've already shared and welcome your questions today. I'll take a minute, I already have introduced them, but to welcome my family and friends who've had my back for a long time. A special nod to my mom, Eileen, and my dad, Vincent, to my level-headed husband, David, who's hiding back there, to my two well-behaved boys, Wyatt, who's a master fisherman, and Sawyer, who's the most voracious reader that I know. They remind me to be humble and to know what's important. They take time, tell me to take time to pick up a badminton racket, jump in the pool, even when I don't want to get wet. That hiking always requires some chocolate. And thank you also to the judges and attorneys who have been my role models. I've learned how to be a lawyer in the district court, and without them, I wouldn't be who I am, and I probably wouldn't be sitting here. I'm a much better advocate for other people than I am for myself, and so I can find my voice in the courtroom, but speaking to you about me is not the most comfortable experience. I'm an only child of two parents who were born and raised in Jersey City, New Jersey. My mom, Eileen, and my dad, Vincent, came from hardworking families. They lived across the street from each other in multi-generational homes. And my grandpa, who I never met, was a Jersey City firefighter and proud member of the United States Navy. And I just learned that 2 generations of firefighters preceded him. And my grandpa Manzak, my poppy, was a welder, and he left the house for work while it was still dark out and came back tired and dirty at the end of the day and grew amazing vegetables in his backyard. And when I see peonies blooming, I think of him. My grandmothers on both sides were frugal women who sacrificed to provide for their families, shopped for the best deals, and held jobs and worked long hours. When I was little, my parents were working, my grandparents would take care of me. And if they were working, I spent the day with my baba. And we communicated through sign language and a handful of Slovak words and food. None of my grandparents attended college, and some not even high school, but they opened doors for their kids. My mom grew up in a home where English was not the first language. So my parents, by going to college, broke the molds they started in, and I deeply appreciate the generational work that has made this day possible for me. By setting their sights beyond Jersey City, my parents gave me a foundation they didn't enjoy but still while staying close to their roots. They prioritized family time and summers at the Jersey Shore. They gave me a long leash to make my own mistakes and to learn from them. And I suppose I had the privilege and safety to fail or succeed. And as a kid, because I knew that my parents had achieved more than they thought possible, exceeding their expectations was often top of mind. When they once wouldn't buy me a sweatshirt that I wanted, I went out and started washing dishes at the corner deli, and I was 12. So I think I've always been willing to roll up my sleeves and put in the effort to find solutions to problems, and I still have that sweatshirt. I told someone that story. So whether through my education, my community involvement, or work, I have tried to extend myself to others and to welcome them. And maybe that's because I came from a small family. I didn't have siblings or cousins or neighborhood friends. If I wanted connections, I had to reach out. And the district court is a community court. It's teeming with diversity, but it only works with connection and partnership, not division. Success in the district court depends on teamwork, and I've worked hard to nurture those relationships there. And I believe that I'm the only attorney in Woburn who's been invited to play pickleball with probation officers, and I know that the court officers always have the best snacks. So my curiosity and my willingness to meet people where they are, and even my commitment to recognizing their values and strengths when there isn't obvious commonality, will serve me well if you approve my nomination. My commitment to justice is not limited to the courtroom, but rooted in the way I live my life. And some of my more meaningful experiences for connection, growth, and understanding happen outside of the courtroom in places where people don't know I'm a lawyer. On some winter weekends, I cook breakfast for an overnight shelter in Malden, and many of those guests spend their days without being noticed, unless to be avoided. And asking guests what they'd like to eat or how they take their coffee and wishing them a good day is not just community service, it's relationship building. And it reminds me to be curious about what we each have in common, even if it begins with cake and cookies. And I thought of another example. I know that we all receive more email than we can keep, but I've kept one message that was written by the mom of the only girl on a flag football team that I coached. And she wrote that her daughter looked at me and listened to me and saw someone who looked like her and sounded like her. And her daughter knew that she could hang with the boys, but having me cheer for her gave her permission to compete and succeed where she might not otherwise have been welcome. And I think that each of us has hidden talents and strengths that shine with support from each other. As talented as I am on the football sidelines, I have, however, spent the better part of my career in the district court, and I feel at home there. I know what to expect. I like the pace of it. I like that no 2 days are the same. And I value the role that the district court has in the community by interrupting patterns of behavior, connecting people with resources, and preventing and remedying harm. But an important reminder that I hear from my clients almost without fail is that the district court isn't comfortable or familiar. For them, it's stressful or chaotic, it can be traumatic. And with that in mind, I would commit myself to treating anyone who appears before me with patience and transparency and respect, whether they're civil litigants or parents looking for help for a child in crisis, victims of crime, or the accused. Each person comes to court seeking understanding and with needs to be met. I won't make decisions that satisfy everybody, but my commitment is that by listening and taking the time to understand the issues and the people who will be before me, I'll make legally supported and factually sensitive decisions, so even when the outcome isn't ideal for everyone, the process feels fair. By understanding the barriers that people face to justice, I will not create additional barriers to help resolving their issues. I'm grateful for the opportunity to serve as a justice of the district court. I look forward to promoting an environment where collaboration is encouraged and where needs are met. And I'm dedicated to ensuring that the public has confidence in our system. I've been humbled by the support that I receive from people who I've worked with for the past 20 years and learned something from each and every one of them along the way. I'll keep those skills and lessons with me should you approve me. Thank you for your time and consideration.
Thank you. Before we get on to the questioning, I just want to introduce a special guest that's here today, our Registrar of Deeds, and most importantly, former Governor's Counselor Eileen Duff, who is present. Counselor DiPaolo.
Thank you, Councilor Kennedy. Good morning.
Good morning.
And congrats on your
Thank you
nomination.
very much.
I apologize, I was traveling this week and we did not connect, but that your home counselor made that extra sure to let me know that his support rested with you, so at least I know that much. In your application, I always look to the question about how you might exercise your discretion on the bench. And among some of the things you mentioned in crafting sentences, you used the word incremental. And I think I know what you mean, but could you expand upon what incremental sentencing looks like in the district court?
Sure, thank you. I think that in most cases, with few exceptions, judges have broad discretion. There aren't many minimum mandatory type sentences in the district court. So when I think of incremental, I think of the complete person who comes before me, whether they've been court involved before, what issues bring them to court. And so incremental sentencing, I think, should start with the position of, is there a diversion program? Is there some way to avoid the sort of stigma of a permanent record? And then absent that, thinking about how is probation appropriate for this person? How can we tailor a sentence that doesn't have to be a jail sentence, but a probation sentence to offer them the support services that they need in order to not reappear in the court again?
So we know, of course, that a lot of folks coming through district court are dealing with substance abuse issues, and the path to recovery involves often many slip ups, and so folks find themselves in a cycle. What's incremental look like at that point if it's the X number of times that someone has violated conditions or whatever it might be?
I think it probably starts with the probation officer and their discretion in if that person's on probation, whether they're issuing a violation notice for every dirty screen something like that. And when it comes before the court, incremental could be considering whether you allow a request for detention by a probation officer, or whether you add additional conditions to give them support and a more structure that seems to be missing. But I think that the important thing to understand with sort of addiction support, substance use disorder, is that it's not a straight path, and that you have to anticipate that there are going to be the stumbles along the way, and that court's really there to support their recovery in the fullest way possible.
And there's some variables there regarding which probation officer someone happens to have, yeah?
There are, and I think that, I think that judges understand that, and understand that sometimes probation officers may be responding to somebody above them, and they're, they have an ask that they have to ask, but judges have the discretion unless.
And it's your role as the judge to how to handle that. How do you handle that ask?
How do you handle that?
Are you gonna give deference to those asks? How do you weigh them?
I think you have to weigh them on a case, on a case by case basis. And so sometimes the person who's asking, or the reason that they're asking. And I think that there's a spectrum. Sometimes somebody might be coming with multiple violations, and there's a serious risk of harm to themselves from their substance use. And so it may be that a brief period of detention is necessary in order to find them appropriate placement in a sort of more intensive treatment option. So those are some of the tools that a judge would have.
My understanding of the current data, and maybe I'm outdated, is that Massachusetts continues to have, or the trend is declining incarceration rates overall, but that's led to kind of a concentration of the groups that were already overrepresented in that population to begin with. And certainly race is something people talk about. I want to ask about mental health and learning disabilities. You weren't in the room, but we just had a hearing for a juvenile judge. And, there's a lot of cycles of incarceration start in childhood, and schools tend to increasingly refer children requiring assistance to the courts. Black and Latinos 3.5 times more likely. The numbers on kids with learning disabilities is very high, and almost certainly underreported, because some kids are referred as a diversion to acquiring special education services. So I'm wondering, when you mentioned moments ago whether they've been court involved as a consideration, that seems like a kind of a coincidence of circumstance too. I'm wondering how do you weigh the court involvement of someone who grew up in a particular community versus someone who grew up in a community where slip-ups were forgiven and didn't lead to police involvement?
I think that's an important question, and I don't want to shine a light on, on my kids, but I'm certainly aware of the benefits of living in a certain community and having maybe police officers who tell you to knock it off or send you home rather than bring you in and arrest you. So I think people come into the court and come before you with whole life experience, and you can't have all the information, but you have to be able to be willing to ask those questions and to consider whether someone's record that they might have prior court involvement is really independent of their behaviors and more reflective of the place they grew up or the policing that they encountered. So I think just being aware of that is the first important step.
Last question.
Okay.
Because those young folks are coming in, the folks I'm thinking of who are cycling out of the juvenile system and find themselves for whatever reason in district court. They've probably experienced difficult circumstances that we know scientifically exacerbate and delay brain development. I'm wondering what your perspective is on how brain development is the role it should play in our criminal system.
I am not entirely familiar with all the science on brain development, but I certainly understand my experience as a parent of young boys who have otherwise had strong support structures. I think that what I'm interested in and learning about is the effect that trauma experiences, aside from what we might identify as a mental illness or youth, but that trauma experiences can really impact and affect brain development for people beyond where we expect them to be, to have matured. So I think that it's important that we, again, operate with all the information that we have available about those individuals, and to keep in mind that their behaviors may not be rooted. I think there's often a tendency to look at how people are behaving and what is oppositional or intentional, but to understand that some of that behavior and some of the reasons that they might be there is attached to brain development.
Thank you. Thank you, Council Kennedy.
Council Jacobs.
Thank you. Well, so I just crossed off a bunch of questions that I was gonna ask that were just asked of you. Some of them I'm gonna ask in a slightly different way, though. Actually, to segue off of where we were just at, let's talk more about neurodivergence and traumatic brain injury. People showing up in the courts who are impacted in various ways and affected by the environment and the nature of what it is to be in court, right? So the sounds, the people, the stress and trauma of whatever reason brought us here today. I'm curious about your thoughts as it relates to from an access to justice standpoint, or what kinds of accommodations should or are being made, should be made, what changes maybe can happen in furtherance of providing greater access to justice for those who are neurodivergent or cognitively impacted.
Thank you for that question. We spent a little bit of time talking about that the other day. And I think, I mean, there are only so many ways you can control the environment of the district court, and it is naturally busy and chaotic. But the extent that I think if I were on the bench, could present a calm demeanor, be cognizant of my body language, of the tone, of my word choice, to not sort of exacerbate those conditions in the court, that's an important place to start, especially because it may help to model behavior for other people that are working there. I think that with specific conditions that may not be visually apparent to people, you're relying on their advocates, their attorneys to bring that information forward. So making it known that I'm receptive to that information and that I want to know as much about your client as possible, I think that's also another important step. And we talked about some other types of accommodations, whether it's scheduling cases at certain times for people so that they're at their best. That's something that I don't see why that should be an impediment. We'd be able to make those accommodations. So those are some of my thoughts.
No, I appreciate that. I think, it's the kind of thing where the more awareness there is, the more attention given to providing flexibility, adaptability, and it's the kind of thing that with intentionality can be helped somewhat. I mean, I think to some degree it's always going to be a challenging environment, but
Yeah.
the scheduling, I think, really did speak to me in terms of well, we talked about it from the standpoint of some people, may well be better in the morning, be more lucid in the morning. They may, the older and sundowning kind of a experience where time frame really helps them participate in their own advocacy better, or for various other reasons where time of day. But also the idea that, and we didn't talk about this, but the follow-up processing of our conversation. Museums and shopping may have times that are quieter times to be more accessible to neurodivergent patrons. Something like that from the court standpoint of thinking through lighting and sound and other things that could be helped. I'm just throwing that out there as a
We talked
things to think about.
in the afternoon when it tends to be quieter for the court, and I'm sure that those kinds of accommodations could be considered too.
Yeah, no, I appreciate that. We had a hearing just before this where one of my questions I think I'm gonna offer to you as well. We talked a little bit about it, but we talked a little bit about drug court, diversion court, specialty court, substance abuse, and that in the probate and family court, there's a family approach to treating or a specialty court that not only just deals with the person or people who have substance issues in the family, but also the family systems, the integrated family dynamics in a holistic way and collaboratively with community resources from all the aspects that are needful. And I was suggesting that, you know, it would be great for our other courts to think about the substance abuse issues that our justice system faces from the family and broader community standpoint in identifying what the issues are and helping to bring resources into play. We talked a tiny bit about it, so I just want to give you an opportunity to your thoughts on how the district court might evolve its own drug court approach, recovery court approach.
No, I appreciated learning about the family court model because I didn't know that. So I agree that, and we talked a little bit about how the specialty courts seem to be so regionalized and that there could be better information sharing and best practice sharing between among the courts. So I think that would be a good place to start. And not every district court has a drug court session. So I would start by expanding the capacity for people who are charged, but not only then people who are charged, but the family members who are impacted by that trauma and also necessary to providing support, for that person. I think another place where those resources could be important is supporting petitioners who come in for mental health warrants or Section 35. I don't want to get too detailed, but often we see them and they're clearly in crisis themselves, not just the person who they're seeking help for. So I think there are places where that could be expanded in the district court.
Yeah, I appreciate that, and I think that's valid. All right, last question. I'm gonna be direct about it, but would you acknowledge that you're a person who has experienced privilege in your life and coming to this point before us today?
Yes. Yes. I mean, I don't think that there's not really any doubt about it. I didn't think about where my next meal was coming from. I always assumed I had a safe place to sleep. I didn't experience, substance use trauma in my house. I had lots of privileges.
So I appreciate that you're aware, acknowledge, and so I from that lead to a question around, we talked about racial biases and disparities that we know are in the courts, and I wanted to hear from you your thoughts around your own awareness of your own biases, any work you've done or any work you think you might do from the bench to be as much as possible, not only unbiased, but maybe aware of when there is racism occurring in the court environment, either through over policing or even just in the way that people interact with each other in your court, awareness around the impact of racism in our courts.
I think it's probably one of the most important issues that we see in the district court. And I personally commit to being humble about what I don't know and what's not my experience, and to being a listener so that I can at least be seen as someone who's willing to hear what somebody else's experiences are. I have heard from my clients, repeatedly about, I think, tools that are helping to bring to light some of the disparities, the longstanding disparities in policing, like whether it's body camera, whether it's individuals using their own phones to record situations and make contemporaneous records. So some of those tools we can rely on in the court for evidence, but I think that I have an obligation when I see racism not to find other words to call it something else, but to put a label on it and to set expectations in my courtroom. And I would not be afraid to do that. It's important that members of the public who are sitting there see someone who may be a white person of privilege who's not willing to accept the racism, whether it's implicit or explicit in her court.
I appreciate that very much. Do I have time for a last question?
Sure, of course. I thought you said that like 6 questions ago, though, but I did that.
My bad.
You're carrying in 5 minutes too, right?
Okay.
I was just gonna say that we're gonna recess at 12 because we have an assembly with the Lieutenant Governor that's only gonna take about 5 or 10 minutes, so I don't want anybody to go anywhere because we're gonna finish. Okay?
This really is the last.
Sorry, go
one,
ahead.
I promise.
Go ahead.
This is just off your application. I don't even think we talked about it, honestly. If we did, I've forgotten that we talked about it. But in talking about one of your cases where there was substance abuse and there was interaction with section 35 and the client voluntarily committed to MASAC, so do we say MASAC?
Yeah, that's that.
Okay. The very end of talking about this case and the work that you did working collaboratively with probation and whatever to really navigate the challenges that your client was facing. I underscored this paragraph that you finished with just because I thought it really, I wanted to hear you talk more about it. And I'm just gonna read what the sentences are, but is that this case is an example of how success requires collaboration, but it also underscores how institutional obstacles interfere with the administration of justice and successful and long-term addiction treatment. So I wanted to give you an opportunity just to expand on that and just give more meat to that statement.
What I was talking about there is, I think, you know, from time to time, you have someone who comes into a district court charged with a crime and clearly is in the substance abuse crisis or a mental health crisis, and they may elect or they may get committed involuntarily for treatment, right? The problem often then becomes trying to get them into the next step of treatment from that institution that's run by DOC, you know, Department of Corrections. And there's a reluctance by the program where they are to plan for something in the future because they don't know what's going to happen with the court case. And there's a reluctance with, you know, sometimes on the court end to allow the flexibility for that programming. So it can get a little bit into this vicious cycle, and it just requires a lot of legwork to make it work out.
Is there a proposed, is there something that could change to help in that type of circumstance?
I think what I've seen most recently are caseworkers at the jails who have been willing to do the work, do the planning, even when the outcome isn't certain. And so I've appreciated the work that I've seen happening in Middlesex and Essex counties on that.
All right, no, I appreciate that, and
Counsel, I know I'm gonna take you out of order, but you're the last person, then we're gonna recess for 10 minutes.
The rest was maybe quick. I have no questions. We have an assembly in 2 minutes. Looks like you got a lot of support here. He's the biggest supporter here. Council Kennedy called me right away. Great resume, great educational background. You calling me.
All right, we're gonna take a 10-minute recess. The Lieutenant Governor ready?
Yeah.
Okay.
started, that's okay. Right, everyone, good to see everyone. I know we got a packed house and a number of things on the agenda today, so why don't I go ahead and kick us off and ask Counselor Dolan for a moment of reflection and for leading us in the Pledge of Allegiance.
Thank you so much. I'd like to call our attention to a recent Superior Court judge who was here for his hearing recently, Charles Gross, who said during his hearing that at times a judge has to show courage. And just reflect that there is another Superior Court judge who is now a U.S. District Court judge who showed courage. That was U.S. District Court Judge William Young, who was first confirmed by the Governor's Council. He heard the case that restored badly needed funds to the National Institutes of Health. And he not only did that, but when he did it, he said it was the worst evidence of racial discrimination by the federal government that he had ever seen. That was courageous. And I hope that all of us and all the nominees who appear before us show that courage too. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good to see you.
Right, good afternoon, everyone. I'd like to recognize Counselor Ianella for a motion to record advice and consent for the financial warrant.
So moved.
Is there a second? Seconded by Counselor Ziegler. All those in favor? Any opposed? The ayes have it. I'd like to recognize Counselor Ziegler for a motion to record advice and consent for the pending list of notaries public and justices of the peace. Is there a second? Seconded by Counselor Ianella. All those in favor? Any opposed? The ayes have it. The record note, Counselor Ferreira has joined us. Nice to see you. I'd like to recognize Counselor DePaul for a motion to record advice and consent for the appointment of Nibal Rahib, to the position of Associate Justice of the Juvenile Court.
Quickly, Lieutenant Governor, I thank the administration for continuing to send us outstanding juvenile judges and especially ones from Worcester. I enthusiastically make that motion.
Thank you. Motion's been made by Counselor DePaulo, seconded by Counselor Jacobs. Any further comments or questions? Seeing none, I would then ask Sonia to please call the roll.
Counselor Powell,
Yes.
Counselor Jacobs,
Yes.
Counselor Ferrer,
Yes.
Counselor Civil,
Yes.
Counselor Dolan, yes, Counselor Ianella,
Yes.
Counselor Sigler,
Yes.
Counselor Kennedy.
Yes.
8 members voting, 8 in the affirmative, the matter carries. And I believe we have 2 new nominations. Emily Carstetter to the position of Associate Justice of the Superior Court. Counselor Kennedy, that's in your shop. If you've got a date and time for a hearing.
Next Wednesday, 1 o'clock.
All right. Very efficient. Next Wednesday at 1 p.m. And then we've also got Thomas Townsend to the position of Associate Justice of Superior Court. Counselor Jacobs, that's in your court for a date and time for a hearing.
I'm gonna follow up with that.
Okay, so to be determined on that one. As a reminder, we will be convening just after 1 p.m. at 1:15 to proceed to the House chambers for the swearing in of Lisa M. Field, the new representative from the South Shore. And I think that concludes our business. I'll entertain a motion to adjourn. Motion made by Counselor Jacobs, seconded by Counselor Ziegler. All those in favor? Any opposed? The ayes have it. We stand adjourned.
Well, that immigration is a hot topic right now in Massachusetts. Have you encountered any issues dealing with your clients that affected you personally, where they didn't even want to appear in court? Or did you experience any traumatic issues with dealing with your client while in court throughout this period?
Thank you for asking that question. It's certainly a timely question, and it was probably 3 weeks ago that I had a client. I didn't realize that he didn't have legal status, and he came to court. I was a second attorney, and we got a quick court date. We made an appointment to meet in my office the week later, and he said he was walking around the corner where he was parked. I ran back to my office to get something I had left behind, and saw that there was a commotion because there were 4 ICE vehicles that had surrounded his car. I approached. The officers were all masked, hats, glasses, tack vests, and they were saying, "Tell him to get out of his car. We're going to break his window." Back and forth, me asking for a warrant, them saying they didn't need a warrant, and then going to a truck, coming out with a form that they had written and signed that moment, said, "This is our warrant. This is the authorization we need." So I advised him that they were going to break his windows if he didn't get out of the car. And I wasn't able to change the outcome, but I was at least able to be a witness to what happened, to get his wallet, to get his cell phone, to get his car keys, to contact his family. And I had another client across the street who recorded that whole thing. And so certainly for me, even someone who's felt confident about the law and my position, it was a scary experience, and it felt intimidating and lawless. So I certainly appreciate the fear that people may be experiencing in coming to court. And I think that sometimes there are accommodations that can be made with appearances by Zoom, or not requiring them for non-substantive dates. And but I'm sensitive to that, and means that they may not be appearing. And I hope, and then even on the other side of it, not just defendants, but people who are affected by crime, the chilling effect it can have on them and reporting it and coming to court for safety.
Sharing that, because I know sometimes, those who are in a position of power, such as being a judge, kind of forget the sense of reality that these things actually happen. And for you to have experienced that, that will open new ideas of how appropriate it would be to give options to clients and to attorneys of what they can do in situations like what you've experienced. So thank you.
I think I saw you that day.
You?
That happened. You were pretty upset.
I was upset.
Oh, you were practically in tears, I remember.
It was upsetting, because I'd like to think that you're going to fix the problem, but at least I knew where he went, spoke to his family, and met with his family, and I did what I could. I thought I could do that day.
Council Ferraro.
Thank you. I visited your hometown in Switzerland last year. What a place.
I left when I was a baby, but it was, it's
Great place.
beautiful. It's beautiful.
As someone who spent 30 years in law enforcement, I want to thank you for your service as an ADA, and you have a great resume. The main 2 reasons of voting for you is, one is Terry and the other one is Kennedy. So I don't have any questions.
Okay.
You gotta make a great judge.
Thank you. It's nice to meet you. Thank you.
Well,
Thank you so much. Yes, Counselor Kennedy speaks very highly of you, and that means a lot to me. I don't have any questions. I'm impressed with your qualifications, very impressed. The story that you just told about your own experience in dealing with ICE and standing up, showing courage, doing the right thing, is very noted and appreciated. And I also want to say that when I asked you that first question, I was kind of kidding, but when we met, I was kind of kidding, but you took the question seriously and you gave me a beautiful answer. Folks, I asked her how she compared to Justice Wendlandt, because I had seen her at the SJC hearing when Justice Wendlandt was having the evidentiary hearing on the CPCS petition, proposed levelly protocol. And you said that she was fact-focused, she brought people back on track, she was well-prepared, she asked questions on her own. And I thought that was a really good answer, and I thank you for that.
Thank you.
I have no further questions.
Council Ziegler.
Thank you.
Take the whole 2 minutes.
Appreciate it. Congratulations on your nomination. I appreciate the time that you spoke you took to speak with me prior to this. So we talked about a lot about the importance of the role that a judge plays. For you, you said the most important are the jobs to identify resources for clients to come before the bench. Can you talk about your process of how you would assess what resources would be most beneficial to individuals coming before you in court?
I think there's an information gathering stage, and that requires the input of different people, different players in the courtroom, whether it's probation officers or the advocate, or maybe attorneys who have dealt with the person before, or or family members, but sort of the information gathering to know as much about what that person's needs are and whether they're being met. And I spoke with Counselor Jacobs yesterday a little bit about identifying resources in the community, and it's not the judge's role or anybody in the court system to start from scratch. There are great resources in the community that are available, and I think I need to do not a better job, but I need to learn more about those and what's available, and being able to match and collaborate with them, because I am not starting from scratch. There are good resources available, and making those connections requires teamwork.
We also talked about the complexity of the cases that would become before you should be confirmed. How would you approach domestic violence cases that would come before you?
I think in our conversation, we talked about the challenges of resolving those, especially where maybe somebody who's charged has a pattern of abuse, or the person who's coming forward to seek help or making the complaint may have a trauma history with repeated interactions or even disappointments with the court process. I think the primary purpose, especially in sort of the initial stages of those domestic violence cases, is public safety and individual safety for the people affected. Making sure that they know that the court is available as a resource to them, and not creating sort of barriers to them reporting and seeking help, and using tools that are available that that litigants rely on, like restraining orders, advocates in the courtroom to sort of keep connection with those parties. I think that you have to do what you can. We talked a little bit about not being able to sort of solve all those problems, but making the resources available and not re-traumatizing people who are coming in with their serious concerns.
Thank you. I appreciate that. I mean, it's definitely something that's important to me, that whoever's sitting on the bench could have a creative approach to cases such as those, because we're seeing more domestic violence cases come before the courts, and safety is always, which we talked about as well, spoke earlier. We also talked about housing insecurity, right? Those are my top two, right? Domestic violence, and ensuring that judges have a good understanding of how to approach those in a way, those cases in a way of empathy, but also cases that have housing insecurity, homelessness within them. Can you talk a little bit more in this public space about strategies around how you would approach cases, sensitive cases that involve clients who are housing insecure?
I think one thing that's important to think about with housing insecurity is that that the system is not criminalizing sort of the condition of being housing insecure. So for those people who come in to court charged with minor offenses that are rooted in their housing security, thinking about other ways other than arresting and charging them, but rather connecting them with resources. And certainly, I think there's also a challenge with people witnesses or victims who are experiencing housing insecurity, keeping contact with them, and not having their cases sort of dismissed because of an inability for them to, barriers that there might be for them to participate in the process. So making sure that they're connected to resources to stay connected with the court system.
I would just say that some of my work like, through, research has really opened my eyes to what that means to be housing insecure. And there's not like any one sort of role or label that you can put on it. People are in those situations for a variety of reasons. It could be, health or job loss or a fire in their apartment. And so my experience there has really, I think, opened my heart and opened my eyes to that. And I would keep that with me on the bench.
I do appreciate that, especially since, you may be seeing quite a few cases come before you, should you be confirmed, that are dealing with complex issues that include housing insecurity and homelessness. And we're seeing things like a national decision that was made, a federal decision that was made, Grants versus Grants Pass decision, which criminalized homelessness, right? Criminalize an individual who is down on hard times and having to sleep in a public space, right? Just more closer to home in Lowell, the same was done as well.
Yes.
Right? And we're seeing conversations like this take place in Brockton and in Springfield, where the push is to criminalize people who are struggling. And so from the bench, you would have immense power to approach these situations with some empathy. And so I appreciate that, you have experience with, meeting with and volunteering to support folks who are housing insecure, and you realize that these individuals are not, they're not people who we think, right? Someone could be housing insecure because they lost their job and they were living paycheck to paycheck, right? There could be someone who had a domestic dispute and their entire financial situation was linked to that domestic abuse partner, right? And so having a lens of understanding complexities around these issues is going to be immensely helpful to those who would come before you in the courtroom. So I appreciate your vulnerability and putting yourself forward, right? And allowing me and my colleagues to ask questions of you relative to understanding the kind of person you would be, the kind of judge you would be, whether you would rule from the bench with empathy, whether you were a person of good character. And I found your responses to be very refreshing, and I appreciate the experience that you today. So thank you.
Thank you very much.
I've only got an hour. We have a 1:15 swearing in, so I've got 45 minutes, okay? I don't have any questions. I've known you since the first day you started in his office, I think, and you're just terrific, so.
Thank you.
I think you know how to count.
Yes.
Sounds like you got enough votes.
Thank you.